When an employee does something wrong, you can always count on somebody having a camera on that employee. The video of the attack on an Uber driver in Costa Mesa by a drunken, angry passenger has gone viral. They usually do. And that marketing executive for Taco Bell, a.k.a. the drunken, angry passenger, was fired by his company. San Diego State business ethics lecturer and attorney Dan Eaton joins us to talk about the rights of employees and employers when these kind of things happen. Dan, this is a question that a lot of people ask. Why are companies often making these decisions to get rid of somebody who, apart from work, does something that looks bad?
Well, because it can affect the company's brand if someone does something untoward, especially one that goes viral. Look, we're living in an age of social media now where things that happen off-duty can instantly become known to millions of potential customers and other stakeholders that a company has. Companies sometimes take action to protect their brand when those things go viral, and that action can sometimes include terminating employees.
I know the argument's been made for a long time about whether or not an employer has responsibility when an employee does something, especially when they're not on the clock. Do they?
Well, the answer is it depends. I hate to give you a qualifying answer, but it does depend. And here's the interesting thing. Under California law, Ernie, the fact is that you generally cannot be fired or otherwise disciplined for lawful off-duty conduct. However, anybody who has seen that video, assuming the man in the video is indeed Mr. Golden, will easily come to the conclusion that what he did to that Uber driver was not lawful. He is shown hitting him repeatedly about the head. And in that circumstance, a company is on much firmer ground in taking action against the employee.
You know, it's hard to imagine that your life is under such scrutiny now, and the fairness of the shaming that social media can bring, it can often leave you outside the worst workforce and really ruin your life.
Well, it really can. It's very interesting. I'm sure a lot of listeners remember reading the Scarlet Letter back in high school, but there wasn't social media back then. If there were social media, Hester Prynne's punishment probably would have been a lot more severe and a lot more durable. The fact is that when every phone is a camera and every outside encounter potentially goes viral, it can have an effect not only on the people involved, but also on the companies for which they work. And sometimes the companies react to that reality by taking action against employees who embarrass them by their behavior.
Now, let me ask you this, Dan. Could this individual Uber driver come back and, by the way, if you haven't seen the video, it's on KOGO.com. Could the individual Uber driver come back and sue the employer of this man who was beating him, for goodness sakes? Could they come back and sue Taco Bell?
What a great question, Ernie. And some of it depends on what Golden was doing at the time. Was Golden, for example, who had a fairly broad-ranging portfolio from what I understand of his duties, was he really coming from a company function, or was he doing something on company business? Was he going to an appointment, which, given his responsibility in, of all things, the social media space, is possible, even given the lateness of the hour? It really depends on whether he was acting in the course and scope of his employment. If he was, then there is at least potentially an argument that his behavior could be linked to Taco Bell. That said, the kind of behavior in which he engaged is going to be very hard for anyone to say was within the course and scope of his employment. So I guess my bottom line is, Ernie, probably not.
I know anybody can sue anybody for any reason. I mean, lawsuits can be brought, but they could be thrown out just as easily. But there's always a concern, and when you see something happen that there's somebody looking for who has the most money that was nearby, let's go after them and somehow try to make a case, tenuous though it might be. And in this type of thing, especially one that's public, you wonder if Taco Bell, just to make this go away, would be willing to pay.
Settlements are sometimes paid for frivolous lawsuits. Everything you said in your question is exactly right, and I have seen it come across my desk on more than one occasion. But the fact is that the law does place certain limits on liability, and sometimes companies would rather fight than pay.
Are we in an era now where companies are just kind of feeling around in the dark as far as how to proceed and what to do? Because it seems there is a knee-jerk reaction. Well, just get rid of them. Well, it's not worth the trouble. Just get rid of them. And that may not be the answer necessarily.
although it may. Of course, in California, we have what's called at-will employment, which is the rule in the vast majority of jurisdictions in this country that says that employees may be fired for good reason or no reason at all, as long as it doesn't offend fundamental public policy. But the question you raise raises a fundamental question of at what point do our lives, our personal lives, our off-duty lives, intersect with our professional lives, and at what point do things that we would normally consider to be our business become our employer's business? And it's at that point, that intersection, in which employers take action. But where employers cross the line, employees sometimes still have remedies.
I wonder how you protect yourself if I'm a business owner, or as an employee, if I'm the employee, can this employee in this case come back if he's fired? Can he go back to Taco Bell and say, you wronged me because of something that had nothing to do with work? It's nothing to do with you.
Not in this case, I don't think, because California law protects off-duty lawful conduct. This was off-duty, presumably, although we don't even know that for sure. But even if it were not off-duty, it clearly was not lawful. So Taco Bell is well within its rights, assuming this man was an at-will employee. But even if he had a contract that required that the termination be only for cause, Taco Bell acted well within its rights in firing this man. A more interesting question is if you vary these facts just a little bit, and then you run into some very troubling questions, both from a legal standpoint and from an ethical standpoint.
In what way? How would you vary the question?
Well, let's vary the question by assuming the man was actually going to an appointment. Let's say he was actually going to Taco Bell headquarters, and that he was actually going to Taco Bell headquarters having just come from a meeting with a client in which he consumed a significant amount of alcohol. Well, the meeting with the client was in furtherance of Taco Bell's business. And if Taco Bell then fired him, I suppose there might be an argument that the connection there created a problem. If he had some sort of a contract with Taco Bell that required that his termination only be for good cause. But again, you're also assuming in that hypothetical that you don't have the violent encounter, that what you had here instead was an embarrassing video where Mr. Golden didn't smack the driver, but was simply told to get out because he was too drunk, and this was recorded on film. Is that enough, absent the assault that Mr. Golden engaged in with the driver? Probably not, to constitute good cause, assuming he had that kind of limitation in his contract, which very few people do. It's important to realize, though, that Mr. Golden was reportedly a very high-ranking employee of Taco Bell. So who knows what was in his contract?
Do you think that, given the fact that everybody is now carrying around a camera, do you think that behaviors, that laws are going to be changed, that social media changes just the fabric of society to some extent?
Oh, it clearly, when every phone is a camera, it changes the essential fabric of a society, because what you used to have a reasonable expectation of privacy to engage in, you really no longer do. When you walk out the door, when you are walking on the street, anybody can record what you were doing at any time, including sound. And that has reputational consequences, not just for you, but for those with whom you are associated, and not just your family, but also your employer. And when it has consequences for your employer, it could have consequences for your employment.
So bottom line, when you leave your house, expect that you're on camera pretty much everywhere.
Well, I hope we haven't gotten to that point. Otherwise, George Orwell was right. He was only about 30 years too early in his prophecy in his famous novel, 1984. We haven't reached that point. There are still certain privacy rights, and California, in particular, which has a constitutional right to privacy in its state constitution, is very protective of that. But the bottom line is that our expectation of privacy is not what it once was.
What is our constitutional right for privacy here in California that we can expect when we do walk out of our house?
In the early 1970s, California voters enacted a provision in the California Constitution that said that you have a constitutional right to privacy. Understand that the federal Constitution doesn't specifically have that kind of right, although one has been inferred by the Supreme Court and other courts. And the question of what expectation of privacy you have as a Californian when you walk out the door is entirely dependent on the circumstances. and that is going to vary depending on where you are. Do you see a phone being pointed at you, or what have you? I mean, there are any range of potential variables that will depend on the evaluation of whether you had a reasonable expectation of privacy or not, and on that determination will turn questions of liability and questions of ultimate responsibility, and what rights, for example, your employer may have, what you may have, and what the person you may have injured may have.
You know, it's interesting. We take film or video and we think, well, this simplifies everything because here's what actually happened. But really, it opens the door to a lot of other questions.
Well, it does, but also you really can't tell what you are actually seeing until you hear both sides of the story. Video, for all of its clarity, can sometimes be very, very deceptive. And so it is not enough for you to see the pictures. A picture may be worth 1,000 words, but the kind of words that ultimately describe that picture still matter.
San Diego State Business Ethics Lecturer and Attorney Dan Eaton with us on KOGO. Thank you so much, Dan. It's great information. I sure hope we can talk to you again.
Thank you.